Hello everyone, welcome to Rao's IAS. I'm Anubhav Sharma. I'm the faculty for Indian Polity and Governance as well as for Public Administration. Today we are going to discuss about this year's prelims paper for Civil Services examination. We are going to discuss specifically all the polity questions. Before we start with the polity questions, let's take an overview with respect to what exactly were the pattern of questions with respect to polity that were asked in this year's exam. Well, when you actually analyze them, you will be able to see that the most of the questions that were asked this year were of easy nature. In fact, this is the consensus that we are having at Rao's IAS among all faculties of polity, that certainly this year's paper was easier with respect to toughness of all the last 3 years papers that UPSC has asked. In this regard, again, something that we need to keep in mind that those 16 questions were asked this year, not all 16 questions were easy. Most of these questions, around 10 to 12, can be considered to be either easy or moderate, but then the rest 3 to 4 questions can also be considered to be slightly tough. What we are going to do in this video is to discuss all the questions that were asked along with the explanation of the right answer. One more thing that I would want you to keep in mind is that this year UPSC has slightly shifted from the way in which they were asking questions till last year. What exactly is this shift? Almost 0 questions were asked from political theory, and almost all questions that came in the exam is having only one definite answer. Something that we need to keep in mind is this generally does not happen for the very simple reason there are questions which require you to know subjective understanding of the exam, subjective understanding of the topics, constitutionalism, meaning of freedom, meaning of liberty, the difference between the two, etc., etc. This year, luckily, there has been no such question, but at the same time, something that we need to keep in mind about UPSC is you cannot predict what will happen in UPSC. You will always have to be prepared. You just don't know that next year they are going to ask more questions with respect to these topics, that is political theory. Be that as it may, let's try to understand every question that was asked this year, question by question. So we've come to the first question this year, and the first question was, how many delimitation commission have been constituted by Government of India till year 2023? In this respect, what we believe is that it will need to be considered as an easy question. Let's try to analyze what exactly this question is about. See, the thing is, what we have is a system where we are having direct elections for Lok Sabha as well as for legislative assemblies. The system that we follow is a single member territorial constituency. That is, whole of India gets divided into 543 territorial constituencies for Lok Sabha, and from every constituency, one member is going to be elected and sent to Lok Sabha. But the question is, how exactly are we going to design these territorial constituencies? What exactly should be the principle that we must apply? Common sense argue, well, it can be the size of every territory should be equal. But then if you think about it, we are a country where distribution of population is also very uneven. We can have some urban areas where population is very high, population density is very high. We can have some areas like hilly regions, or for that matter desert regions, where population is going to be less. That means if at all we are letting size of the territory to be the basis on which constituency will be designed, it would be unfair for the reason every constituency of equal size is not going to have equal population. Keeping that in mind, it is necessary that we are designing constituency not keeping in mind the territory, but keeping in mind the population. That means we essentially should be having constituencies which are having equal population. By this logic, what exactly will happen? More is a state which is populated, more essentially will be number of constituencies a state will be getting. That is why the most populous state of India, Uttar Pradesh, has a maximum number of constituencies because of this only. That is, because it has the maximum population, it will be having maximum number of constituencies. In this respect, now the question should be, but sir, how exactly are we going to design these constituencies, because population keeps on changing? And it makes sense. In this regard, what we had done, we decided that we are going to have what we call as delimitation commission, in which election commission is going to play a very central role with respect to designing of constituencies. So what we had, we essentially gave the power of delimitation, that is, designing constituencies keeping in mind the population of every constituency as far as possible should be same as compared to other constituencies. But then population isn't something that is static, it keeps on changing. So the idea was that, well, every 10 years we are going to conduct census. And after the census, we will get real data with respect to what exactly is the population of every constituency. And that is why almost every 10 years, we also are going to constitute what can be called as Delimitation Commission, which is going to look into what exactly is the way in which today we are going to design constituency. Think about it. There will be areas which are getting more populated because of urbanization. There could be areas where death rate has been higher as compared to birth rate, so their population is declining. In this respect, what is happening continuously, population of different constituencies are changing, and you require Delimitation Commission to look into the latest data available with respect to population to decide what exactly should be the way in which we must design new constituencies or constituencies that exist right now. As such, it makes sense that, well, we need to have a delimitation after every census. If at all we are talking about students who haven't studied about this in detail, they would think, well, after every census we should be having delimitation. That means we must have had delimitations as many as the census that we have conducted, and that would be completely wrong. Why? And this is where details becomes important. So what exactly had happened? We essentially had conducted the first delimitation in 1952, because 1952 is the year when we were having the first election for both Lok Sabha as well as for the state. Then, based on 1961 census, 1963, again delimitation was done, Delimitation Commission was set up, again constituencies were designed, and again based on 1971 census, Delimitation Commission had submitted its report in 1972, based on which again we had redesigned our constituencies keeping in mind the population census of 1971. But then something happened. We are talking about the era of 1970s, when Indira Gandhi was the prime minister, when we were having the government of Congress with Indira Gandhi being the prime minister. At that time, number of measures were being taken with respect to population control. And one of the things that was realized was the fact that if at all we are letting population to become the prime determinant of the constituency, there will not be any incentive on the part of MP and MLA to decrease their population, because they essentially would want their population of their constituency should always be higher, so that they are able to always make sure the size of their constituencies as small as possible to increase their chance of winning. Another thing that was realized at that point was that population is actually making number of states very nervous with respect to their representation in Lok Sabha and Rajya Sabha. Think about it. More is the population of the state, more will be the number of members they can send to Lok Sabha, more will be the number of members they can send to Rajya Sabha. If at all their population keeps on decreasing as compared to other states, their representation as a result of the system is also going to decrease. Keeping that in mind, it was realized, you know what, we need to give this sense of confidence to the people, to the states, that we are not going to decrease your representation, and you need to work now towards family planning, now towards controlling population. As such, what exactly was done in 42nd Constitutional Amendment Act, we decided to freeze the constituencies based on 1971 data. That is 1971 census. That means based on this delimitation that was done. What exactly was said? That we are not going to change the constituencies, we are not going to set up delimitation, but for what till then? But till 2000, that is when we are conducting the first census after the year 2000. Based on that, again we are going to do delimitation exercise. Again, we essentially are going to redesign our constituencies. That makes sense. Then what happened? By the time we entered the year 2000, we essentially were able to see some massive demographic changes across states in India. We were having some of the southern Indian states which now were having relatively lot less population as compared to North Indian states, and the reason was very simple. Industrialization and development of state results in decline in its population. More the state is developing, it has been seen world over, the population will be decreasing. On the other hand, some of the states in northern part of India were not able to develop at the same rate, at the same pace as South Indian states. That led to what? Their population disproportionately increasing. As such, now in the year 2001, if you again are doing this delimitation exercise, what is going to happen? The number of representatives that South Indian states are sending to Lok Sabha is going to drastically decrease as compared to number of members who are going to come from North Indian states. And mind you, we are right now, that is in 1990s, we were in coalition era. So whosoever is the party which is in center who would need to maintain their government in Lok Sabha at the union level, they would need to get the support of some of the regional parties, and the South Indian regional parties were very important at that time. Keeping that in mind, what exactly was done? It was decided, you know what, time has not come for us to again do delimitation and change the representation of every state in Lok Sabha and Rajya Sabha. As such, it was decided, you know what, we essentially are going to postpone delimitation till the year 2026. In other words, we are going to have delimitation exercise after the first census that will happen after the year 2026. In this respect, what exactly is the idea? Again, we have frozen constituencies for next 25 years. But at the same time, there was a discussion, a debate that had occurred. The debate and discussion was that what exactly is the biggest concern of the states? The biggest concern of the state is that they don't want their representation to decrease in Lok Sabha and Rajya Sabha. As such, if at all we are able to freeze the number of seats for every state in Lok Sabha and Rajya Sabha, that should take care of their concern. In this aspect, if you think about it, it's one thing that from a particular state you're having certain number of people who are being sent to Lok Sabha and Rajya Sabha, but demographic shifts have happened within that state as well. It's not that demographic changes are happening across different states. Within a particular state, now there will be certain constituencies which are more populated, certain constituencies which are relatively less populated. You would require redesigning of constituencies to be done within a state. Keeping this logic in mind, it was decided, while we are not going to change the number of seats that are coming from every state, be it for Tamil Nadu, be it for Kerala, Karnataka, Uttar Pradesh, Gujarat, etc., within every state, Gujarat, Uttar Pradesh, Kerala, Tamil Nadu, we are going to have a delimitation exercise by which now the constituencies within the state are getting rationalized in a manner in which now it reflects equal number of people. As such, what exactly was done? We had conducted another delimitation exercise in year 2002. In this, what we need to keep in mind is the representatives from every state to Lok Sabha, Rajya Sabha was not changed. Only thing that was changed was what? The way in which constituencies are going to be within a state. Is it clear? That means so far we have had 4 delimitation commissions that have been set up, and as I said, the next perhaps will happen after the year 2026. Now, let's talk about what exactly could have been the reason why UPSC has asked this question. One, of course, is the fact that this is an election year. We are having Lok Sabha election. We had Lok Sabha elections. That means we need to know about some of the basics with respect to constituencies, how they are designed, how many times we have changed the constituencies. Another way to look at it is what? The declaration, the announcement that was made by Modi ji with respect to, that is Prime Minister, with respect to reservations for women, where it was said that after delimitation exercise, seats will be reserved for women in the parliament. That means something has been asked from static part of your Indian polity, but its roots are coming from current affairs, current events that are happening. This is one of the classical thing that UPSC does. It appears as if the question is from static, but if at all you're analyzing it in the hindsight of the current events that has happened, you will see, well, it can also be linked with current events. And that is why this is one question that we had covered in our foundation, we had covered in our Focus magazine, we had covered in our DNS, and we had also covered in our QIP. Is it clear? Now we come to the next question that was asked in polity, that is a question with respect to Article 368. What exactly the question says? As per Article 368 Constitution of India, the Parliament may amend any provision of the Constitution by way of addition, variation, repeal. The question requires us to answer how many of these statements are correct. 1 and 2 are correct, 2 and 3 are correct, 1 and 3 are correct, or all of the above, 1, 2 and 3 are correct. Let's first try to understand the concept and then we'll get to the answer. What exactly is the concept? The thing is, we essentially are talking about amendment of Indian Constitution. So it's like this. Indian Constituent Assembly decided to create Constitution of India. The logic was very simple. Now anything and everything that is going to happen in India, in Indian political system, the way in which state would function will be based on what is written in the Constitution. In this respect, if at all legislature, be it that of union or for that matter of state, has made a law which violates the Constitution, Supreme Court will have the power to perform judicial review and hold it null and void. But at the same time, it was realized it is also necessary that we also keep a mechanism within Constitution by which we can amend the Constitution. Because, well, the idea is that, well, you are able to create the best that you can in the time in which you are. So with the idea of keeping 1950, everything that was happening around the world, everything that had happened in India before freedom struggle, our Constituent Assembly created the best constitution that they could have. But you never know, in future you would require constitution to get amended, to get better. You would want new things to be added to the constitution. You would want more clarification to be given to provision of the constitution. You would want certain things which might not be relevant to even get repealed from the constitution, because your constitution should always be reflection of society of the time in which constitution is getting applied. Something like right to privacy might not have been important in 1950 with respect to a fundamental right, but it certainly is very important in 2024 because we live in a digital world. As such, it was decided, you know what, we need to keep a provision with respect to amendment of Indian Constitution, and that provision, that article was Article 368. It actually contains the provision, the article that talks about how exactly amendment of Indian Constitution can occur. So if you think about it, the question is not that tough, because the question is asking you to tell us whether you know this article, and if you know this article, which of course talks about amendment of Indian Constitution, does it include any addition to Indian Constitution? Of course it does. Does it include any variation to an existing provision of the Constitution? Yes, it also includes that. Or does it also allow us to repeal anything in Indian Constitution? And we know this also is included under the provision of Article 368. Let's take some examples. Addition. What we can do is to add new things into Indian Constitution. For example, we had added Article 21A that talks about right to education. Now it has become a fundamental right. What we can also do is to bring about certain variation by which we are able to bring about some clarity. For example, what we had done, we had made it through 42nd constitutional amendment mandatory for president to abide by aid and advice given by Council of Ministers. So if you think about it, it isn't as if aid and advice of Council of Ministers to the president was not written in the constitution. You have just brought a variation to make it explicitly clear that it is going to be binding on the president. Similarly, in 42nd, after 42nd, that is 44th constitutional amendment, we also brought one more variation. Well, what exactly was done by Janata Party? Janata Party said that we are going to have aid and advice of Council of Ministers to president to be binding, but president at the same time can also have the option of sending it back to the cabinet, back to the Council of Ministers for reconsideration. But if the same advice is being sent by the Council of Ministers back to the president, then it would be binding. If you think about it, we aren't actually changing the substance of the constitution as such. All what we are doing is to bring certain variation by which we are able to bring about more clarity. Again, it becomes very clear. Variation is something that you can do with 368, 44th constitutional amendment, as I said. Repeal, we had something called as right to property as a fundamental right. It was repealed. It was added as Article 300A. In other words, again, repeal is something that can be done with Article 368 in this respect. What exactly is the idea? Which option is going to be correct? 1, 2, and 3. Option D. Now we come to the next question. Again, this question can be categorized as easy in nature. At the most, it can be categorized as moderate. But by and large, for the students who have been sincere, this question will be categorized as easy. What exactly is the question? With reference to union budget, consider following statements. What is statement number 1? Union Finance Minister on behalf of Prime Minister lays annual financial statement before both houses of the Parliament. Then the second statement is, at the union level, no demand for grant can be made except for recommendation of President of India. The question requires us to tell us whether both statements are right, whether both statements are wrong, or is it that one statement is right or one is wrong. Let's try to understand these statements. The first statement is saying Union Finance Minister is going to present the budget, but the budget will be on behalf of Prime Minister of India. Of course, it is wrong. The budget will not be introduced on behalf of Prime Minister of India. Even if you have studied the bare acts of Indian Constitution, you would know Finance Minister is introducing budget on behalf of President of India. What else? At the union level, no demand for grant can be made except on the recommendation of President of India. Again, if you have studied even the bare acts, you would know, yes, the statement is true that you cannot have any demand for grant without it being approved by the president. That is, you need prior approval of the president, prior consent of the president in order to introduce any demand for grant. Let's try to understand both these statements so that we are having conceptual clarity. This is something that we need to understand when we actually talk about aspects like annual financial statement, money bill. We are actually talking about ways through which government can take money from Consolidated Fund of India. I hope you know that when you talk about Indian Parliament, it's a bicameral legislature. That is, we are having two houses, Lok Sabha, where people are elected directly by the people, and Rajya Sabha, where people are elected indirectly by the people, and they are getting elected by the members of state legislative assemblies of the states from which they come from. For example, Kapil Sibal comes from Uttar Pradesh. He's a member of Rajya Sabha, and he was sent in the Rajya Sabha by a member of Legislative Assembly of Uttar Pradesh. In this respect, whenever we want to pass any bill, the idea was it should be approved by both houses, both by Lok Sabha as well as Rajya Sabha. Lok Sabha, where people are directly elected by people of India, members are directly elected, here members are indirectly elected, and Rajya Sabha is there in the parliament in order to provide a federal balance. All decisions of national importance should be taken in light of interest of the state as well, and that is what Rajya Sabha is trying to ensure. Thus, generally for anything and everything, you would want both Lok Sabha and Rajya Sabha to passing a bill, and once both houses have passed it, then only it will go to the president. But when we talk about money bill, when we talk about money being taken from Consolidated Fund of India, it is necessary that it can only be moved in Lok Sabha, and it only requires approval of Lok Sabha. It does not require approval of Rajya Sabha. The idea was very clear that we essentially do not want the government at the center to get crippled with respect to taking money from government treasury, Consolidated Fund of India, because we are not able to get federal balance, federal support of the states. So we thought it makes sense that we need to give this power to Lok Sabha. This is the practice that is also there in USA. This is the practice that is also there in UK, and we are just continuing the same system. But at the same time, you would also want that there are certain checks in place with respect to how exactly Lok Sabha can take money, can take grants, can pass an annual financial statement, which is indeed talking about the budgetary allocation for different schemes of the government. So we have put a check that if at all government seeks to introduce a money bill, if at all government seeks to introduce annual financial statement, it can be done with prior approval of the president. President will need to see that yes, it's a money bill, it has been told to the president, and then only it can be introduced. In this respect, what exactly is the idea? At the union level, no demand for grant can be made except on the recommendation of the president, which is absolutely true. When it comes to the first statement, Union Finance Minister, is he producing introducing the annual financial statement on behalf of Prime Minister? Of course not. In parliamentary democracy, you are always representing Council of Ministers, and we, as we have already discussed, Union Finance Minister here is introducing the annual financial statement on behalf of President. Again, this is something which cannot be categorized as a tough question. It is an easy question, and I would imagine most of you must have got it right. This brings us to question number 45, the next question that is there in polity with reference to Parliament of India. Consider the following statements. What is the first statement? Prolongation of House by the President of India does not require advice of Council of Ministers. Any student who has read any basic conceptual polity book would know the statement is wrong. If at all, President seeks to prorogue the House, it is necessary that she is doing it on the advice of Council of Ministers. What is the second statement? Prolongation of a House is generally done after House is adjourned sine die, but there is no bar to the President of India to prorogate the House which is in session. Again, a very basic question for the people who have studied. They must be knowing that yes, indeed, this is a correct statement. Dissolution of Lok Sabha is done by President of India, who, save in exceptional circumstances, does on the advice of Council of Ministers. The question is about how exactly President of India can dissolve Lok Sabha. In this regard, yes, President of India is going to dissolve Lok Sabha on the advice of Council of Ministers. So we have 2 and 3 which is correct, and 1 of course is not correct. Now let's try to understand the concepts behind this question and how exactly we are supposed to understand it. Okay. See, the thing is, if at all we want our parliament to make laws, it becomes very necessary that this house is in session. They are coming, they are meeting, they are discussing, they are debating, they are voting, etc., etc. That means we would want our session of the parliament to begin, and that is what we call as summoning of session. How exactly that occurs? It occurs when President of India summons the House. President of India summons the House on the advice of Council of Ministers. That means if at all a session of the Parliament has to be summoned, it can be done except for exceptional circumstances by the advice given by Council of Ministers. Then once the session has begun, there will be number of sittings, there will be number of debates. We essentially are going to vote on issues, etc., etc. There will come a day, there will come a time when you would want to end the session. Ending the session is called proroguing the session, and this again is done by President, and this is done on the advice of Council of Ministers. In this respect, you may ask, sir, aisa kyun hai? Why exactly we essentially are having a system in which a session can be prorogued, a session can be ended on the advice of Council of Ministers? The reason is very simple, that when you think about it, how exactly someone will get the power in Lok Sabha is when a party, is when the person, Prime Minister, is enjoying majority with respect to confidence of Lok Sabha. That means whichever party is in majority, whichever coalition is in majority, is the coalition which will be able to decide the Prime Minister, will be able to decide the ministers, etc., etc. That means if at all in Lok Sabha, government wants to introduce a bill, it is going to be not that tough for them to get it passed, because it is because they have majority in Lok Sabha is why they are running the government. That means every government bill at least will get passed by Lok Sabha without any problem, because you only require simple majority. As such, if at all there is some important legislative business which is yet to be completed, if there are certain bills that government want to be passed in this session of Lok Sabha which is going on, it should be that they must be allowed to present it and get it passed. In this respect, it should not happen that without their consent and House session of the House has been prorogued and many of the important legislative business has not been completed. Thus, we have this practice where what exactly happens? Session of the House will be prorogued by the President on the advice of Council of Ministers. What else? Prorogation of the House generally is done after the House is in adjourned sine die, but there is no bar on the President for prorogating the House which is in session. Now let's try to understand this statement. See, the thing is, the very moment a session of Parliament has begun, you're going to have multiple sittings within that session. In this respect, the power has been given to the presiding officer to decide how exactly they would want to conduct these sittings. There will be sittings of number of hours, and you would want the sitting to get adjourned. Whenever Speaker in Lok Sabha is adjourning a sitting of the House, Speaker also will need to mention when exactly the next sitting will happen. Let's say Speaker says that, well, I'm adjourning the House and next sitting will happen after 2 hours after lunch break. The next sitting will happen at 8 a.m. tomorrow. It can also be the next sitting is going to happen on Monday. The idea is it has been left to the speaker to decide how exactly these settings will need to be conducted and how exactly the time for the next sitting will be decided. In this respect, if you think about it, speaker can keep on doing it. When I say speaker, I mean presiding officer. So it can be chairman of Rajya Sabha and Rajya Sabha as well. So coming back, if we look at this system, one can clearly see that well, speaker can decide on this question till the point we essentially are coming close to the date of prorogation. Now what happens is speaker gets intimated by the president in advance that well, I am going to prorogue the house. I am giving orders with respect to prorogation of the house on a certain date. This tells the speaker on what date he is supposed to end all the sittings that has occurred so far in the house. In this regard, let's say for the sake of example, president says on 1st July we are going to prorogue the house. In this regard, what exactly is the idea? Speaker must try to conduct the last sitting on or before 1st July. Let's say on 1st July, what exactly happens? Speaker decides that I'm going to now have the last sitting. But now the thing is, while speaker can adjourn the last sitting of the session, what exactly is the next date he can give? Nothing. For the very simple reason, the next date of the next sitting is going to be in the new session of the parliament, and the power to summon the session lies in the hands of the president. As such, what exactly speaker would say or presiding officer would say, I am adjourning the session and this is adjournment sine die. That is, I am not setting the next date of when we essentially are going to come and meet again. In this respect, once adjournment sine die has happened, President of India will release official orders with respect to prorogation of the house. In this respect, there can be a confusion. The confusion is it necessary for the president to prorogue the house just because adjournment sine die has happened? Of course not. For the very simple reason, adjournment sine die has happened because prorogation decision or order has been given. In other words, what I'm trying to say here is that if at all president has said that well, I'm going to prorogue the house on 1st July and speaker decides to issue adjournment sine die on 15th June, that means speaker has announced there are going to be no more sittings for this session. Is it binding on the president to now prorogue the house on 16th June? No, it isn't. President can choose to prorogue the house only on 1st July and issue the order. That means session will go on although speaker has announced adjournment sine die. What can also be the situation? Let's say president has not given a date of prorogation and still what exactly has happened? Speaker essentially has issued adjournment sine die. Again, the doubt could be now that adjournment sine die has been issued by the speaker, by the presiding officer, is it necessary for the president to issue orders of prorogation? Again, it is not necessary for the president to issue orders of prorogation. Session will keep on happening though we are not having any more sittings. What could be the purpose why they essentially are asking such a question? The reason is they just want to know whether you have clarity with respect to concepts. Because a lot of time people might think, well, it is because adjournment sine die has happened is why prorogation is happening. No, it's the other way around. It's because prorogation needs to happen is why the last sitting has been adjourned by the speaker, by the presiding officer, adjournment sine die. And that is what is getting tested. Let's look at the statement again. Prorogation of the house is generally done after the house is adjourned sine die, which is true, but there is no bar on the President of India to prorogue the house which is in session. I hope this statement is clear why exactly it is right. Then next statement, dissolution of Lok Sabha is done by President who, save in exceptional circumstance, does so on advice of Council of Minister. That again is something that I have explained. Yes, this is the way it happens. Now let's try to understand this as well. See, the thing is, when you actually talk about Lok Sabha, we know Lok Sabha gets a term of 5 years. That means every 5 years, Lok Sabha is going to get dissolved. In this aspect, what exactly is the thing that we need to keep in mind? It is necessary that we are conducting elections and any Lok Sabha is not serving for more than 5 years. In this aspect, is it necessary that it is only on that date on which fifth year is getting completed is when Lok Sabha will need to be dissolved? Not necessary. Prime Minister of India, who is heading the Council of Ministers, can actually go to President and request President to dissolve the House even earlier. In this aspect, what exactly can happen? Let's say only 4 years, 10 months have been passed, but Prime Minister believe that, well, time has come that we should be having a new Lok Sabha. We essentially are going to go for new elections. I request, Madam President, that I want you to please dissolve this Lok Sabha. In this regard, what exactly will happen? On the request of the Council of Ministers, President will dissolve a Lok Sabha. In this aspect, there can also be those exceptional circumstances where President can choose to act on her own if at all President believes it could be a malified advice. For example, let's say we are talking about a situation in which President has made someone a caretaker Prime Minister and has given that person some time by which he is able to get majority in Lok Sabha. Let's say 15 days has been given. On the 13th and 14th day, the person is getting very nervous because the caretaker Prime Minister is not able to convince others to join the coalition and give him support in Lok Sabha. As such, this Prime Minister might want to abuse the provision of the Constitution and would want to give a malified advice to the President that, Madam President, I am requesting you to please dissolve Lok Sabha and have new elections done. President can choose to ignore such an advice. As such, this will be considered as one of the exceptional circumstances where President can choose to dissolve Lok Sabha even when the advice is saying something else. Are you able to understand? On the other hand, there can be another exceptional situation. What exactly can be that exceptional situation? Think about it. Let's say there is a coalition government, and this coalition government has lost the majority in Lok Sabha. In this aspect, President is trying to figure out a way by which we can create a new coalition. But then it seems it is not possible for even other parties to be able to get into a coalition which has majority in Lok Sabha. In this regard, President is left with no other choice but to dissolve Lok Sabha, even if Prime Minister and Council of Ministers has not advised it to the President, because it is necessary on the part of President that whosoever is having the power of executive is enjoying majority in Lok Sabha. That again can be that exceptional situation where what can happen? President can choose to dissolve Lok Sabha even without advice being given by Council of Ministers. I hope that clears this question. Dissolution of Lok Sabha is done by the President, who, save in exceptional circumstances, does so on the advice of Council of Ministers. So 2 and 3 are correct, and 1, of course, is incorrect. This brings us to the next question, that is question number 10. Which of the following statements are correct with respect to Ethics Committee of Lok Sabha? So we need to know the basics with respect to Ethics Committee, and if we know the basics, we will be able to answer this question. There are these 3 statements from which we need to identify which all statements are correct. The first thing that should come in your mind is कि इस साल ही सवाल आया क्यों? Why exactly this question was asked this year? The reason is very simple. One of the things that was in news for the majority of last year was about Mahua Mitra and how exactly Ethics Committee of the Parliament was looking into her conduct. It was also in news because number of experts are arguing even today that nature of functioning of Ethics Committee overlaps with that of Privilege Committee. If you were watching DNS lectures that we were having at Rouse, if at all you were reading the Focus magazine, if at all you were attending a QIP classes, you would know at multiple points, at multiple times, we have covered this topic. But again, the takeaway is it is very important for students to make sure that they are in touch with current affairs, and more so they are also reading about those current affairs. They are also reading the static part of those current affairs. What exactly are these statements? The first statement is Ethics Committee initially was an ad hoc committee. In this aspect, if we have studied about it, we would know yes, it was. See, essentially what had happened was in 1996, there was a conference of presiding officers that had taken place in New Delhi. At that time, it was decided, you know what, we require a mechanism that was present in number of other democracy, that is having a kind of ethics committee with respect to parliament, with respect to parliamentarians. See, the logic is very simple. When we talk about member of parliament, we see that they get number of parliamentary privileges. We see they get number of parliamentary immunities, things that happen inside the house, except for exceptional circumstances, cannot be challenged in a court of law. As such, it could be that there are some very important grave issues with respect to ethical conduct of a particular MP, which might be not getting cognizance, which we essentially are not able to hold that MP accountable for. In this respect, it could be that there is an MP who might have engaged in some sort of ethical conduct, and it is necessary that we are determining what exactly can be the actions that can be taken against this person. In this respect, it was decided, you know what, we should be having ethics committee. And initially, ethics committee was made as an ad hoc body. What is an ad hoc committee? It's a committee which is getting formed in the parliament for a specific purpose. Once the specific purpose is met, the committee will be dissolved. But then in 2015, we decided to create this committee as a permanent committee. That means initially it was an ad hoc committee, and then it became what is called as initially it was an ad hoc committee. Now it is a standing committee. Make sense? Then what's the second statement? Only a member of Lok Sabha can make a complaint relating to unethical conduct of a member of the Lok Sabha. What exactly is the idea? The statement is saying that in Lok Sabha they are members, and if at all there is a member who has committed any kind of thing that can be held as unethical, a complaint can be filed. But the statement is saying that only a member of Lok Sabha can file a complaint, and this is not correct. Anyone, any citizen can file a complaint with respect to unethical conduct of a member of parliament, and the idea is it is not limited only to a member of parliament. What exactly is the procedure? Procedure is pretty much simple. In this, if at all you are an MP of Lok Sabha, all you need to do is to file a complaint. But if at all you are a citizen, you will need to approach any MP of Lok Sabha, and you will need to ask that MP to raise the matter on your behalf. But this time you also will need to produce an affidavit. An affidavit where you're saying that what you're claiming with respect to something unethical being done by an MP is true. And in this respect, if at all it is brought to the notice, it essentially is identified eventually that what you were saying was a false statement, it was something which was lie, it was malicious, then the person who had filed the complaint can also be charged under it, can also be punished for it. Matlab, what must be understood? Well, the procedure is if at all you're an MP of Lok Sabha, you do not require an affidavit. You can directly go and register a complaint against any other MP against whom you believe that person has done something unethical. But if at all you're a citizen, if at all you're not the member of the House, if you're not the member of Lok Sabha, can you go and file the complaint? Yes, you can. But here the catch is you first will need to go to any MP of Lok Sabha, and that MP on your behalf is going to file the complaint. Only thing is you will also have to submit an affidavit of veracity of your claim, that what you're claiming, what you're saying is true. So in this respect, what exactly we see, the statement is incorrect. Then this committee cannot take up any matter which is sub-judice, that also is true. Let's try to understand this statement. See, think about it. What we have is a court of law. What we have is judiciary. In judiciary, there are matters that are going where judiciary and judges are supposed to apply their mind wisdom by which they are able to give judgment. Anything and everything which is right now under the consideration of the court is called to be a sub-judice matter. The idea is, on one hand, we have given a parliamentary privilege to our parliamentarians that you can talk about anything, you can discuss any matter. But should it be this parliamentary privilege should be taken to an extent in which we start discussing issues which are right now under the consideration of the judges? In this respect, the idea is no. Whatever is a matter which is sub judice, that will not be discussed in the floor of the House. What exactly is the reason for it? The reason is very simple. It essentially has an effect by which you are putting pressure, popular pressure on the judiciary to give a judgment, to give one form of judgment. See, the thing is, when you talk about member of parliament, member of legislative assemblies, these are people who are very popular. That is why they won the election, and that is why they are inside the House. So whenever they say something, there are so many people, thousands and crores of people who are listening and accepting what they are saying. On the other hand, when we talk about people who end up becoming our judges for High Court and Supreme Court, are not the people who are winning any kind of election. They are not popular beings. They are just people who were able to go through the system. They were able to clear the system by which they have been given this very important role of performing judicial review, of performing judicial administration. In this respect, it becomes very necessary that we are not putting on our judges any kind of undue pressure. As such, it is not allowed for Parliament to discuss matters which are sub-judice, because it in a way will compromise the independence of judges. It in a way is going to put undue pressure on judges in order to give one kind of judgment. The same logic applies here. Yes, it can be that one MP has been charged with respect to something which is unethical, but right now court is looking into it. Right now, there is a judicial court which is looking into whether this person is guilty or not. In this respect, it would not be fair if you're allowing ethics committee also to sit as a court and look into whether the person, what he did was right, ethical, unethical, etc., etc. As such, it is very clear that this statement is wrong. This statement is correct, that committee cannot take up any matter which is sub judice. So 1 is correct, 3 is correct. The answer is going to be 1 and 3, that is C. This brings us to the next question, that is question number 44. With reference to Indian Parliament, consider following statements. What exactly are the statements? A bill pending in Lok Sabha lapses on its dissolution. What exactly is this question is about? The question is about how exactly dissolution of Lok Sabha happens with respect to its impact on the bills that were pending. That means effectively UPSC is seeking that the aspirant should be knowing about the basics with respect to the impact of dissolution on what exactly will happen to a bill which is pending in Lok Sabha, Rajya Sabha, etc., etc. The first thing is, why exactly such kind of a question has been asked this year? One simple explanation is because this is the year when we are having Lok Sabha elections. This is the year where the previous Lok Sabha is going to get dissolved and we are going to get a new Lok Sabha. In this respect, it should be a matter of curiosity for an aspirant. What will happen to all the bills that are pending in Lok Sabha? What will happen to all the bills that were passed by the previous Lok Sabha and it was pending in Rajya Sabha? Is it that they are going to lapse, or is it that new Lok Sabha is going to discuss about the bills that were passed by previous Lok Sabha? Thus, what is expected is aspirant should be having clarity with respect to how exactly a bill can lapse at a time when Lok Sabha gets dissolved. Make sense? So what exactly is the statement? A bill pending in Lok Sabha lapses on its dissolution? Yes, it does. What is the situation we are talking about? Let's say we have Lok Sabha and Rajya Sabha, of course, and there is a bill that has been introduced in a Lok Sabha. In this respect, what exactly has happened? Before Lok Sabha could have voted on it, this Lok Sabha got dissolved, new elections has been called upon, and now we have a new Lok Sabha. In such a scenario, all the bills that were pending in Lok Sabha is going to be lapsed, for the reason you would want the new members, the members of new Lok Sabha, to decide what exactly are the type of bills they would want to form and discuss. As such, it becomes very clear that the bill which is pending in Lok Sabha is going to lapse the very moment it gets dissolved. What is the second statement? A bill passed by Lok Sabha and pending in Rajya Sabha lapses during the resolution of Lok Sabha. What exactly is the idea? What we are saying is the situation. What we have is a situation where there was a bill that was introduced in Lok Sabha. It was then passed in Lok Sabha, and we know when a bill is passed in Lok Sabha, it is going to go to Rajya Sabha. Now, Rajya Sabha right now is discussing this bill. In other words, Rajya Sabha has not voted on this bill. Rajya Sabha has not said yes or no. Rajya Sabha only is discussing this bill, and that is why this bill is right now pending in Rajya Sabha. But then, while this bill was pending in Rajya Sabha, Lok Sabha, which had passed this bill, gets dissolved. That means this Lok Sabha will get replaced by a new Lok Sabha. The question is, what exactly will happen to this bill? Because this bill is different from the bill that I just discussed, because this bill has been passed by Lok Sabha. In this respect, again, what exactly will happen? This bill will lapse. You may ask, sir, why exactly this bill will lapse? The reason is very simple. that this bill is having legitimacy because it was passed by Lok Sabha, but the members who were part of that Lok Sabha which had passed this bill themselves are now removed, themselves have been changed. In this respect, it becomes very necessary that we would need to take opinion of this Lok Sabha to decide what exactly are the bills that you would want Rajya Sabha to consider and not consider. That means if at all, even if this new Lok Sabha wants the same kind of bill to be passed, they again will need to pass it. Once they pass it, then it will go to Rajya Sabha. Now only Rajya Sabha can discuss this bill which was passed by the previous Lok Sabha will now lapse. I hope this point is also clear. So what happens? A bill passed by Lok Sabha and pending in Rajya Sabha lapses on dissolution of Lok Sabha? Yes, it does. What's this third statement? A bill regarding President of India, a bill regarding which President of India has notified her intention to summon the House for a joint sitting lapses on dissolution of Lok Sabha. In other words, the question is that if at all there is a bill for which President has called for joint sitting and then Lok Sabha gets dissolved, then bill also gets slapped. This is absolutely incorrect. That is, if at all we know the basics with respect to joint sitting, we would know this is now how it happens. Let's get some clarity with respect to joint sitting. What exactly happens in joint sitting? See, the thing is, what we have is a system in which we have Lok Sabha and Rajya Sabha, and we would want any bill to be passed by both houses before it could be sent to the president for assent. That means if we want to make a bill into a law, it is necessary, except for exceptional circumstances, that it has been passed by both houses. So there can be a situation where what is happening? There is a bill that was introduced in Lok Sabha and Lok Sabha decided to reject it. Or there is a bill that was introduced in Rajya Sabha and Rajya Sabha decided to reject it. In both this equation, in both these situations, what exactly is happening? What we are getting is a very clear answer that mandate of the people is not behind this bill. As such, this bill cannot be passed. Absolutely fair. But there can be one more situation. What exactly is that situation? What exactly is that situation? There is a bill that originated in Lok Sabha. Lok Sabha decided to pass it and then it went to Rajya Sabha. Rajya Sabha, upon consideration, decided to not pass it. In other words, there is a bill which has been passed by one house, that is Lok Sabha, and it has not been passed by Rajya Sabha. A very similar situation can happen in this way also. A bill has been passed by Rajya Sabha, then it goes to Lok Sabha, and Lok Sabha decides not to pass this bill. In this respect, what exactly is happening? You are having one house which is saying that, well, we are giving our mandate, we believe this should be made into a law, but the other house is saying, no, we do not believe this bill to be made into a law. In this respect, there is a confusion as to what exactly Parliament wants with respect to such a bill. Under such circumstances, it can be said a deadlock has happened. What is a deadlock? One house has passed it while the other house has not passed it. It has rejected it. There is one more way in which a deadlock can happen. If let's say there is a bill which has been passed by Lok Sabha, it goes to Rajya Sabha and Rajya Sabha has not acted on it for 6 months. That is, Rajya Sabha has not voted yes, or they have also not voted no. All what they have done is to sit on it. They have decided not to do anything on it. That means already 6 months have been passed. It's a situation that can be called again as a deadlock. क्योंकि bill तो stuck हो गया ना. The same can be said the other way around. Rajya Sabha passed something. It is there in Lok Sabha. It is pending in Lok Sabha. Now we have a bill which has been pending in Lok Sabha for more than 6 months and it was passed by Rajya Sabha. Again, it can be said a deadlock has occurred. Whenever there is a bill where a deadlock occurs, there is something President can do. President can call for joint sitting. What basically happens in joint sitting? President will say, well, I have a bill for which there is a deadlock. I want a definite answer for it. I am asking both Lok Sabha and Rajya Sabha to convene together on a particular date. For the sake of example, let's say the date is 1st August. I am asking Lok Sabha, Rajya Sabha to convene at a particular date, that is 1st August, and on that date they are going to discuss the bill and then they are going to vote on the bill. If with simple majority the combined strength of Lok Sabha, Rajya Sabha is able to pass the bill, then it's fine. If they are not able to pass the bill will be dropped. Baat hi khatam. In this aspect, something that we need to keep in mind is there can be number of bills which essentially are getting subjected to deadlock. But it is not binding on the president that for all the bills he requires a joint sitting. Only those bills which of course have achieved a deadlock, which are subjected to deadlock, but president also believes only this particular bill will need to be put to joint sitting, only then president has to do so. That means president can also choose to not call for joint sitting if president does not want it. I think this must be clear now. In this aspect, based on what we have just understood, there can be one confusion that can occur. Sir, आपने बताया that well, president can call for a joint sitting, but then let's say president said that on 1st August for this particular bill, which has been passed by Lok Sabha, which has not been passed by Rajya Sabha, I want joint sitting. And before 1st August, let's say for sake of example, 20th July, you essentially had what? You had Lok Sabha getting dissolved. Now there is no Lok Sabha. Something that we have already understood, if at all you are not looking into a case of joint sitting, and under normal circumstances this would have happened, such a bill has lapsed. It was passed by Lok Sabha, it is pending in Rajya Sabha, and now Lok Sabha is dissolved, such a bill will also lapse. The question is, will it also lapse for a bill where president has already called a joint sitting? No, such a bill will not lapse. That is, now that president has said joint sitting will happen, at that time Lok Sabha was functioning. As such, even though Lok Sabha is dissolved, the new Lok Sabha is going to come and is going to be a part of this joint sitting. That means before dissolution of Lok Sabha, if joint sitting has been called upon over a bill which has attained deadlock, and after announcement of joint sitting, the Lok Sabha gets dissolved, for such a bill for which joint sitting has been called will not lapse. You will wait for new Lok Sabha to get convened and you will have a joint sitting with Lok Sabha and Rajya Sabha put together. This indeed was the question that was asked. That's the third statement. A bill regarding which President of India has notified her intention to summon the House to a joint sitting lapses on the dissolution of Lok Sabha. In this regard, we know it does not lapse, joint sitting will happen. So third is wrong. It is incorrect. Answer will be 1 and 2, that is B.
Hello everyone, and I would be taking forward the discussions on the polity questions that have been asked in the prelims of 2024. Now this question was asked in the prelims of 2024, which of the following statements are correct about the Constitution of India? Power of the municipalities are given in Part 9A of the Constitution, emergency provisions in Part 18, and amendment to the Constitution in Part 20. It's a straightforward question. It's an easy question. Why? It's a Rotland answer. And if you have good memory, it's likely that you'll do well. And in the past also, UPSC has been asking this kind of questions. Part 3 in relation to fundamental rights, Part 4 in relation to DPSP. And you have to now remember all the parts of the Constitution. There are not many, but you would have to remember. So if you look at Part 9A, does talk about the municipalities. If you look at Part 18, it does talk about the emergency provisions, and Part 20, amendment of the Constitution. Coming back to the question, the answer would be D, 1, 2, and 3. All the 3 statements are correct. Moving on to the next question. Under which of the following articles of the Constitution of India has the Supreme Court of India placed right to privacy? Now, this is one of the more famous questions of UPSC. They've asked this multiple times within prelims examination and once in mains examination. The Supreme Court provided right to privacy in the Puttaswamy judgment under Article 21, right to life and liberty. It has been asked multiple times previously in UPSC examination. It was asked in 2018 in relation to right to privacy. It was asked in 2022, right to privacy, and it has also been asked in mains examination in 2017. So if you've done your PYQs or previous year questions properly, this is one of the easiest questions that has been asked in polity this year. The next question is, a writ of prohibition is an order of the Supreme Court or High Court. One of the things I and almost every other faculty and toppers end up saying is read the NCRTs. And if you see class 11th NCRT, Indian Constitution at Work, and within class 11th, you also have political theory. Both of them are important for prelims examination. There is a chapter 2. Within this, they have provided various writs, the basic definition, which you can use in your mains examination also. And if you look at prohibition, they have said this writ is issued by a High Court or Supreme Court, when a lower court has considered a case going beyond its jurisdiction. So it would be issued by the Supreme Court to the High Courts or lower courts, or it could be issued by the High Courts to the subordinate courts. Why? Because they have exceeded their jurisdiction. Now, questions on constitutional remedies have been asked in the past. One of the PYQs has been on mandamus. And if you see the Constitution, Article 32, within right to constitutional remedies, part of the fundamental rights, provides that the Supreme Court has the power to issue writs in the nature of habeas corpus, mandamus, prohibition. Similarly, the power of the High Courts under Article 226 is also to issue writs of prohibition, mandamus, habeas corpus, and 2 others for both Supreme Court and High Courts. So within that context, if we go back to the question, which one would be the correct answer? C. The lower courts are prohibited continuation of proceedings in a case. Why? Because they're exceeding their jurisdiction. The next question, it is the governor of a state who recognizes and declares any community of that state as a scheduled tribe. The second statement, a community declared as a scheduled tribe in a state need not so be in another state. So if you look at, again, the Constitution of India, under Article 342, it provides that the president will provide for a state or union territory after consultation with the governor and notify tribes and tribal communities. So going back to the first statement, it would be incorrect. Why? Because it is not the governor, it is the president. Looking at the second statement, in the National Commission for Scheduled Tribes, let me just recommend, when you're doing constitutional bodies, statutory bodies, or any other body, go to their website. There is a section, FAQs, frequently asked questions. One thing that we have noticed is UPSC, or within the prelims especially, has a habit of taking statements from the FAQs. They're an authentic source, and sometimes the exact statement would be taken. And it's an easy way to prepare for your prelims examination. So within the FAQs of the National Commission for Scheduled Tribes, there is a particular line. Thus, the list of the scheduled tribes is specific to a state and union territory, and a community declared as a scheduled tribe in a state need not so be in another state. This question also is related to current affairs. A little back in 2022, the cabinet approved 4 tribes, 2 in Tamil Nadu, 1 in Himachal, and 1 in Chhattisgarh as scheduled tribe. Within the article itself, it talks about the fact that the Binjia community, sorry if I'm mispronouncing, were given scheduled tribe status in Chhattisgarh, but they had already scheduled tribe status in Jharkhand and Orissa. By reading this article, also you can take the call, and by understanding society better, that it's not necessary for one community that has been declared as a scheduled tribe in one state to also have scheduled tribe status in another state. Going back to the question, the correct answer would be B, 2 only. With reference to the Speaker of the Lok Sabha, consider the following statement. While the resolution for the removal of the Speaker of Lok Sabha is being considered, the UPSC has given 3 statements. He shall not preside, he shall not be entitled to the right to speak, and he will not be entitled to vote on the resolution in the first instance. What resolution? The resolution to remove the Speaker of the Lok Sabha. Going back to the Constitution, Article 96 talks about the removal of the Speaker of Lok Sabha and the Deputy Speaker of Lok Sabha. One of the things it ends up saying is, if a resolution has been introduced in the Lok Sabha to remove the Speaker, then the Deputy Speaker presides. If a resolution has been introduced within the Lok Sabha to remove the Deputy Speaker, then the Speaker would preside. So within that statement, this would be correct. The Speaker will not preside when a resolution for his removal is being considered in the Lok Sabha. Who would preside? The Deputy Speaker. However, within the same article, you also have that the Speaker shall have the right to speak and he is entitled to vote. Why is this the case? Why is he entitled to speak and be entitled to vote on a resolution of his own removal? It comes back to a particular question, and that is there in the Constitution, that you would have one individual who occupies two constitutional offices. So that is there with the Vice President, who is also the ex officio chairman of the Rajya Sabha. One person occupying two constitutional offices. Similarly, the Speaker is also a member of Parliament. And as a member of Parliament, he has the right to speak. As a member of Parliament, he has the right to vote on such resolution. It's not a conflict of interest. And therefore, within that context, both statement 2 and statement 3 would be wrong, because he is entitled to speak and he is entitled to vote on the resolution in the first instance. The correct answer therefore would be A1 only. Now these are the questions that I would be discussing, and now Naweed sir would take forward the discussion on rest of the polity questions.
Now let's take this question number 2 from set D. It says Constitution 71st Amendment Act 1992 amends 8th schedule to the Constitution to include which of the following languages? Options are 1. Konkani, 2nd Manipuri, 3rd Nepali, and 4th Maithili. Now this is a very factual question. In this you need to know that the Constitution 71st Amendment Act 1992 amended or added which of the following. So here these were the 3 languages which were amended through the Constitution 71st Amendment, whereas Maithili was amended through the Constitution 92nd Amendment. So here the question is select the correct answer using the code given below. So of course the first option, that is 1, 2 and 3, becomes the correct answer here. Moving further, this question says which one of the following statements is correct as per the Constitution of India. And this question is based on various entries under the Union list and the state list. First one says interstate trade and commerce is a state subject under the state list. Now this is a very basic fact. If you have studied properly, then you would have known that interstate trade and commerce is a central subject and not a state subject. So your basic understanding of commercial transaction or your basic understanding could have eliminated this particular option. Next, interstate migration is a state subject under the state list. Okay. Next, interstate quarantine is a union subject under the union list. Okay. Next, corporation tax is a state subject under the state list. Now we all know that corporation tax is under the central government or in the union list. So this option would also have been eliminated, and this remains as to which one would have been the correct answer. Now, if you would have been following the news in the COVID crisis, then you would have known that interstate quarantine is a union subject under the union list, whereas interstate migration is also a subject under the union list and not state list. And if you look at the entries under union list, so these are the various entries under union list, namely interstate trade and commerce, entry 42, interstate migration or interstate quarantine, that is entry 81, and entry 85, that is corporation tax. Now other than this, with respect to trade and commerce, Article 301 of the Constitution of India says that freedom of trade, commerce and intercourse subject to the other provisions of this part, trade, commerce and intercourse throughout the territory of India will be free, and Parliament shall have power to impose restrictions on trade, commerce and intercourse. It further says that Indian polity has a federal structure, but an arrangement is necessary to ensure harmonization and facilitate interstate trade and commerce without hindrances. Hence, interstate trade and commerce and some elements of intrastate trade and commerce are central responsibility. Now, this is not part of the Constitution, rather taken from the Department of Legal Affairs. So in this, the correct answer was C, that is interstate quarantine is a union subject under the union list. Moving ahead, Now this question is with respect to money bill. So you are supposed to know the basics with respect to money bill. This question says which of the following statements are correct in respect of a money bill in the parliament. Now you have to know the basics. So let's go through the options. First, Article 109 mentions special procedure in respect of money bills. Now generally when we study about money bill, we generally focus on Article 110. We seldom focus or we'll seldom go through Article 109. So let's go through Article 109 first and then try to answer the question here. It says special procedure in respect of money bill. So straight away this is your first statement. Second one says a money bill shall not be introduced in the Council of States. I think this is your second statement. So very clearly, directly questions have been taken from the bare act of the Constitution of India. So look at the second statement, a money bill shall not be introduced in the Council of States. So both these statements are correct according to Article 109. If you can see here, as it says, special procedure in respect of money bill and a money bill shall not be introduced in the Council of States. The third statement says, the Rajya Sabha can either approve the bill or suggest changes but cannot reject it. Okay. And the fourth statement says amendments to a money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha. Now to understand this, let's go through the provisions further under Article 109. It says after a money bill has been passed by the House of People, that is Lok Sabha, it shall be transmitted to the Council of States, that is Rajya Sabha, for its recommendations, and the Council of State shall within a period of 14 days from the date of its receipt of the bill return the bill to the House of the People with its recommendations, and the House of the People may thereupon either accept or reject. So it is not mandatory upon the House of the People or the Lok Sabha to accept any of the recommendation provided by Rajya Sabha. So going by this provision, the fourth option is incorrect. That is, amendments to a money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha. No, this is not the case according to Article 109. So in this, the third statement becomes correct. That is, the Rajya Sabha can either approve the bill or suggest changes but cannot reject it. Question was, select the correct answer using the code given below. So here 1, 2 and 3 is the correct answer. That is, C is the correct answer to this particular question. Moving further, question number 20. Now before discussing about question number 20 with respect to Northeastern Council, I must highlight here that this is one of the toughest questions asked in the section of polity and governance, and there have been a lot of confusions with respect to this answer. So let's go through what the question states and let's try to understand what should be the answer. Okay. Question says the Northeastern Council was established by the Northeastern Council Act 1971. So the question is focusing on the legislation which created the Northeastern Council, that is the Northeastern Council Act of 1971. Subsequent to the amendment of NEC Act in 2002, the council comprises which of the following members? So it is asking that there was an amendment made in 2002, and after that, that is subsequent to that amendment, who are the members of the Northeastern Council? Options are Governor of the Constituent State, Chief Minister of the Constituent State, 3 members to be nominated by the President of India, and the Home Minister of India. So there has been confusion with respect to the last option, that is whether Home Minister of India is a member of NEC, that is Northeastern Council. Now please understand, the amendment of 2002 does not exactly mention the term Home Minister in the legislation, right? Secondly, Home Minister has been made the chairman of NEC ex officio, and this has happened in 2018, right? Now let's go through the act first, and then we will go through the 2002 amendment and also try to understand this through a notification of the Government of India. Now this is the act, that is the NEC Act, and section 3 says setting up and composition of the Northeastern Council. It says there shall be a council to be called the Northeastern Council, which shall consist of the following members, namely 1, 2 and 3. The person or persons for time being holding the office of governor of states. So governor being one of the members. Next, the chief ministers of the states of Arunachal Pradesh, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim and Tripura. So chief ministers becomes another members of the NEC. Third, 3 members to be nominated by the president. So these are, it says, clause 1 says that there shall be a council to be called the NEC, which shall consist of the following members, namely, first, the governor of states, chief minister of these states, and third, 3 members to be nominated by the president. So far, there is no doubt as such, because all these 3 have been given as our option here. Now, the doubt, if any, comes with respect to the fourth one, because Home Minister is the ex officio chairperson or chairman of the Northeastern Council. Now, this is the 2002 Amendment Act of the NEC. This also says that there shall be a council to be called the Northeastern Council, which shall consist of the following members, namely, the person or persons for the time being holding the office of governor, so basically the governor, then the chief ministers of the states of Arunachal, Assam, Manipur, Meghalaya, Mizoram, Nagaland, Sikkim and Tripura. And the third one, the 3 members to be nominated by the president. And it then says for subsection 3, the following subsection shall be substituted, namely, the president shall nominate the chairman of the council. So this is according to the 2002 Amendment Act. Now look at the notification issued by the government. Now this is the notification issued by the government, and this is under Ministry of Development of Northeastern Region, a notification of 2018. So it says that notification dated I think 10th March 2005, published in the Gazette of India. The president hereby makes the following nominations with effect on and from the date of publication of this notification in official gazette, and further orders, namely, that Union Minister of Home Affairs to be the chairman ex officio. So the word mentioned here is only chairman and not member. If you go ahead, it says Minister of State in charge, Ministry of Development of Northeastern Region to be a member ex officio, and Minister of State in charge, Ministry of Development of Northeastern Region to act as vice chairman. So vice chairman is also a member, but the Home Minister is ex officio chairman but not a member. So based on this notification and also based on the parent legislation, namely the Northeastern Council Act of 1971, which mentions these 3 persons to be the members of the council, the answer here should be A, that is 1, 2 and 3 only. As the question was, select the correct answer using the code given below. See, it's possible that there could be doubt with respect to this question, and it's also possible that UPSC might later on come up with another answer. So by our suggestion to you as student would be that in case you think this question, you can drop out this question or you cannot attempt this question, because this is technically one of the toughest question from the section of polity and governance. But as of now, we are going with the answer A, that is 1, 2 and 3 only. Moving to the next question, that is question number 21. It says, consider the following statements regarding Nari Shakti Vandan Adhiniyam. So this question is with respect to Constitution 106th Amendment Act. First statement says, provisions will come into effect from the 18th Lok Sabha. Now this statement is based on the conceptual understanding of the commencement of this act. Now commencement of this act, or for the commencement of this act, let's go through a provision which has been added through this particular legislation. So it says here that after Article 334 of the Constitution of India, the following shall be inserted, namely 334A. So it says that notwithstanding anything in the foregoing provisions of this part or Part 8, the provisions of the Constitution relating to reservation of seats for women in the House of the People, Legislative Assembly of the State and Legislative Assembly of National Capital Territory of Delhi shall come into effect after an exercise of delimitation is undertaken for this purpose, after the relevant figures for the first census taken after commencement of the Constitution Act 2023 have been published, and shall cease to have effect on the expiration of a period of 15 years from such commencement. So after this act came into being, that is, this act came into being in 2023. So after this, the first census, which will happen post 2026. So post 2026, the tenure of Lok Sabha would be 19th Lok Sabha and not 18th Lok Sabha, because the tenure of 18th Lok Sabha is from 2024 to 2029. So in that sense, this statement becomes incorrect. Next, this will be in force for 15 years after becoming an act. Yes, this statement is correct. Next, there are provisions for the reservation of seats for scheduled caste women within the quota reserved for the scheduled caste. Now, this statement is also correct if you look at this particular provision, namely 330A clause 3. It says that as nearly as may be, 1/3, including number of seats reserved for women belonging to the scheduled caste and scheduled tribes of the total number of seats to be filled by direct election to the House of the People shall be reserved for women. So this statement becomes correct here. So 2 and 3 is correct. So the question is, which of the statements given above are correct? So of course, apart from 1, so here the correct answer would be C, that is 2 and 3, because the first statement is incorrect.